So therefore, in the WTO system, it is pretty well recognized that issuance of compulsory license is a very important flexibility in the TRIPS agreement, which countries can use whenever they have to respond to a public health need. Now, compulsory license in Indian Patent Act, this is given in section 84(1) of the Indian Patent Act. There are a host of other sections which I'm not going to talk about, but just to introduce this, in the Indian Patent Act, the Act says that at any time after the expiration of 3 years from the date of grant of patent, any person interested can make an application for issuance of compulsory license on 3 grounds. And these grounds are: first, the reasonable requirements of the public with respect to the patented invention. Second, the patent invention is not available to the public at a reasonably affordable price. And thirdly, that the patented invention is not worked in the territory of India. Now, once such an application is made, then the government will decide whether a compulsory license should be issued or not. There are also provisions where the state can suo moto decide to issue a compulsory license under the Indian Patent Act. Now I come to the developments which have taken place in the last couple of years, which Vishwas also mentioned in his introductory remarks, which has made me revisit this topic again. And this relates to, as I presume many of you would know, that in March 2012, India issued a compulsory license to a domestic generic manufacturer, Natco, for a drug, anti-cancer drug, which is patented by Bayer. Bayer is a German company. Now, this compulsory license was upheld by the Intellectual Property Appellate Board. It was again challenged by Bayer, but it was also upheld by the Bombay High Court. And it was also decided that in this compulsory license which has been issued, royalties have to be paid to Bayer on a quarterly basis at the rate of 6% of the net sales of the medicine. As a consequence of the issuance of this compulsory license, the price of this patented drug has come down drastically, and as a result, it has increased the accessibility and affordability of this particular medicine to a large number of patients who could not afford it when there was no compulsory license issued. So this is a very good example to demonstrate that how a country like India has used this very important flexibility to ensure that there is greater affordability and accessibility of a drug which earlier was restricted to only those who could afford it and at a very high price. Now I come to the main part of my presentation. So far I have tried to lay down 2 points basically, that compulsory licenses is an important flexibility. The Indian patent law recognizes this inconsistent with the TRIPS agreement. And therefore, the issuance of compulsory licenses is very much consistent with India's obligations under the WTO. However, the question that I'm going to pose, and which is the main part of my presentation, is that assume a scenario where Bayer decides to challenge the issuance of this compulsory license under the India-Germany BIT. India has a bilateral investment treaty with Germany. I will explain for those who are not aware with investment law what is a BIT and why is it important. And I'll try to answer this by saying that why am I asking this question? Now, I'm asking this question because of 2 reasons. First is the global context and second is the national context. In last 2 decades or so, the number of bilateral investment treaties have increased from 500 to more than 3,000. Now, these bilateral investment treaties are treaties signed by 2 countries to protect investment made by investors of each other. Now, the origin of the bilateral investment treaties was to ensure that investment made by investors of capital exporting states gets protection in the markets of capital importing countries. So the origin of the bilateral investment treaties was from Europe, then it followed to the US, but now you have a number of developing countries who have started to enter into bilateral investment treaties with other developing countries. So the first BIT was signed in 1959. And since 1959 till the end of 2013, as per the statistic given by UNCTAD, the number of bilateral investment treaties has increased to more than 3,000. Now, till about 1990s, these BITs didn't assume that much of importance because there were very few disputes that came up under bilateral investment treaties. However, in last 2 decades or so, the number of disputes under bilateral investment treaties have increased exponentially. As you can see, that the number of disputes have increased from 50 in about early 1990s to more than 500 now. So it's almost a 10-time increase in disputes under bilateral investment treaties in last 2 decades. Now, there's a very important characteristic of these bilateral investment treaties, which is that these treaties allow the foreign investor to directly bring a claim against the host state. So, the foreign investor need not have the sanction of the home state. The foreign investor on his own can bring a claim against the host state. This is pretty unprecedented in public international law. If you compare this with the WTO, for example, the WTO only recognizes a state-state dispute resolution mechanism. So, even if you are an aggrieved trader, aggrieved by the regulatory measure of a particular country, you on your own cannot bring a WTO claim against the other country. You have to request your home government to bring a case against that particular country. Whereas in the bilateral investment treaties, it is the foreign investor individually in its private capacity which can bring a claim for breach of public international law against the other state. And it is this specific characteristic of BIT which makes BITs very, very important and perhaps what they are today. Now, over the last 2 decades in these disputes which have come up, they have covered a host of regulatory measures. So, for example, there have been instances where countries have adopted a regulatory measure for protection of public health, and this has been challenged by investors as violation of the BIT. Similarly, there are numerous examples where states have adopted regulatory measures for protection of environment, and this has been challenged as violation of BIT by the foreign investors. There's this slew of cases against Argentina, where Argentina, because of a very severe economic crisis, adopted certain monetary measures, and these monetary measures were challenged by many American, French, English investors as violation of different BITs that Argentina had signed with these countries. So as a result, what has happened is that there's a huge backlash against the BIT regime by many countries, not just developing, even developed countries, arguing that these BITs do not allow countries enough regulatory space to adopt regulatory measures to govern issues domestically. And this includes public health also. Now, given this global context, what has happened in India in the last 2 years is this. India has been signing BITs since 1994. However, from 1994 till about end of 2010, BITs never figured or never occupied a very important place in the Indian policy making establishment. I can say this because I have some first-hand experience of this. During my PhD studies, whenever I used to go to meet Indian officials who were negotiating on BITs, I was often told that you're wasting your time doing research on something which is of no consequence. This was in 2009 to early 2010, because they said, well, if you are telling us so many problems of BITs, why have no foreign investors brought cases against us? That question got answered after 2011 onwards. Now India has about, from the information which is publicly available, not by the Indian government but from other sources, about 15 investors have brought cases against India for violation of different BIT obligations that India has undertaken with 15 different countries. This ranges from cancellation of telecom licenses by the Supreme Court to imposition of retrospective taxation in case of Vodafone to a host of other regulatory measures. Now, since there has been globally increase in investor-state disputes, and since there has been an increase of disputes against India, therefore, this question becomes very important, that can a foreign investor like Bayer, for example, use the India-Germany BIT, or it can be any investor if India were to issue a compulsory license again in future, to use the BIT to challenge the issuance of compulsory licenses. So they will not challenge this under the WTO. They will not use the WTO as a forum, but they might be tempted to use bilateral investment treaties. Now, if the foreign investor decides to use bilateral investment treaties, what is the possibility of the investor being successful? Now, the investor will first have to surpass the test of jurisdiction. The investor will have to show that the Investment Treaty Arbitration Tribunal, which is constituted under the BIT, has jurisdiction over a claim on violation of a patent right. Now, for jurisdiction, the Investment Treaty Arbitration Tribunal will have to look at the definition of investment in the BIT, which is a very important aspect to establish whether the tribunal has jurisdiction or not. Now, you will find it interesting to note that the definition of investment in all Indian BITs is defined in a very broad manner. It is known as the asset-based definition. which covers intellectual property rights within its ambit. So which means that if a patent right has been conferred on a foreign company for a drug or for anything for that matter, then that is very much a part of foreign investment. And if you do anything which tinkers with this particular right, then it means that there could be a possibility of you impacting the foreign investor's investment, and therefore the jurisdiction of the Investment Treaty Arbitration Tribunal will be triggered. So the first question which I posed, can issuance of CLs be challenged under BITs? The answer is yes, it can be challenged for the very simple reason that the definition of investment in all the Indian BITs includes intellectual property rights, and therefore it includes patents as well. So any regulatory measure which impacts this patent right of the foreign investor can be challenged under the BIT. Now I come to the second and the more important question, that is, if the investor passes the jurisdictional hurdle, then whether this challenge will be successful or not. Now for this I will first have to talk about expropriation. Vishwas, how much time do I have? Okay, I have time. Okay. So for this I'll have to first talk about expropriation and introduce to you to the concept of expropriation so that you will be able to follow the presentation. Now, one of the important characteristics of bilateral investment treaties is that they prohibit states from expropriating foreign investment. Unless or until this expropriation is in public interest, due process has been followed, and fair and equitable compensation is paid to the foreign investor. So unless or until these three conditions are present, expropriation would be unlawful. If these three conditions are present, then the expropriation would be lawful. Now, bilateral investment treaties cover both direct and indirect expropriation. If you look at the Indian model BIT, for example, the phrase used in the expropriation provision is measures that have an effect equivalent to direct expropriation. So it is not just an instance where you revoke, say, the right of the patent holder, but it will also cover those instances where you indirectly expropriate the foreign investor's investment. To give you a very simple example, a foreign investor has been given a license to operate. You don't revoke, the state doesn't revoke the license, but the state creates environments because of which, or state does something because of which the foreign investor is unable to enjoy or work on the investment. So this will be a case of indirectly expropriating the investment of the foreign investor. Now, it is very well established in investment treaty arbitration jurisprudence that both direct and indirect expropriation are unlawful. Now, all Indian bilateral investment treaties cover or provide protection to foreign investors both from direct and indirect expropriation. Now, how do we determine whether expropriation has taken place? There is no consensus on this, and from the different cases that have come up in last decade or so, there are primarily three tests which have been used. The first and the most important test is known as the sole effect test. The sole effect test focuses on the effect of the measure on foreign investment, which means that if the regulatory measure has an effect which is equivalent to substantial deprivation of foreign investment, then it will amount to expropriation. What is the purpose behind the regulatory measure is not considered in this analysis. What is considered is what is the impact of that particular regulatory measure on foreign investment. So if a compulsory license is issued, for example, and if this compulsory license results into substantial deprivation of the patent holder's right, then it could come close to being an expropriation under the sole effect test. The second test which some of the tribunals, not all, have used is known as the purpose test, according to which if the regulatory measure is in furtherance of public interest, then it will not be expropriation, notwithstanding the impact that it has on the investment of the foreign investor. Now, this particular test is problematic for two reasons. Firstly, because this test attacks at the concept of expropriation itself. It is important for all of you to understand that the state is not prohibited from expropriating. The BIT only says that if you expropriate, then you have to pay compensation and should be in public interest. So public interest is recognized as a ground for expropriation. But in the purpose test, public interest will be used to determine whether there is expropriation or not. So this comes in conflict with not just the rules of treaty interpretation, because it ignores the plain and clear language of the text of the BIT, but it also creates a conceptual obfuscation by sort of undermining the very concept of expropriation. The third test which some tribunals have come up is known as the proportionality test, where the outcome of a regulatory measure being expropriation or not will depend on the application of the three-step proportionality test. Now, we all know that this three-step proportionality test, first step is that whether there is a causal relationship between the objective that the measure seeks to achieve. Secondly, whether the measure is necessary, which means there is no less restrictive alternative measure that can use the same objective. And third is proportionality stricto sensu, which means that the restriction imposed on the right of the patent holder should be proportionate to the objective or the public interest that you seek to achieve. Now, if all this were to be applied in case of India, then what will be the scenario? Whether issuance of compulsory license will be expropriation or not will depend on arbitral discretion. This is the first point that I want to make, because it is the arbitral discretion which will decide which test is to be used. There are instances where similar languages of the BIT, similar instances where the focus is solely on effect, have been interpreted by different tribunals, and different tribunals have used all the three tests to decide whether there is expropriation or not. So, in other words, the answer to this is that it will depend on the discretion of the arbitration tribunal. If you look at the Indian bilateral investment treaties, a large number of them focus only on effect as the sole criteria to determine expropriation. The language in large number of Indian BITs is very clear, saying that measures having an effect equivalent to expropriation are to be prohibited. So the focus in the text is clearly only on the word effect, which points towards using the sole effect test. Now, if a sole effect test is used, then the foreign investor, in the example that we are discussing, the foreign investor will have to show that the issuance of compulsory license has resulted into substantial deprivation of my investment. It is not enough to show that there is some adverse economic impact on my investment. Some adverse economic impact or ordinary adverse economic impact, or showing that, oh, my profits have fallen from $10 billion to $8 billion or $7 billion is not sufficient to show that there is expropriation. You will have to demonstrate that there is substantial deprivation. Now, again, the question that comes to our mind is that what do we mean by substantial deprivation? There is no one answer to this question, because the text of the treaty is absolutely silent on this. There are different tribunals that have given different tests on this. One test is the legal test, which is whether the investor is in control of the investment or not. If the investor is still in control of the investment, then it is not substantial deprivation. The economic test is what is the economic impact of the regulatory measure on foreign investment. So in this case, it will be what is the economic impact of issuance of compulsory license on the patent right which the foreign investor enjoys. If this economic impact is substantial, then arguably it would be a substantial deprivation of foreign investment and therefore expropriation. If purpose test is used, as I said, which test will be used is not certain, because the text is pretty ambiguous, so it gives room to the arbitration tribunal or for lawyers for that matter to argue for all the three tests. So if the purpose test is used, then we can safely say that issuance of compulsory license will not be expropriation, because then it can be very clearly shown that this issuance of compulsory license is for furthering a very important public interest like public health. We want to make medicines affordable and accessible to people. It's a very important public interest. Nobody will dispute this, and therefore it is not a case of expropriation if the purpose test is used. If the proportionality test is used, then the host country will have to demonstrate that the requirement of necessity is met, that there is no other less restrictive alternative measure which will achieve the same objective, and secondly, that the restriction imposed on the rights of the patent holder is proportionate to the public health objective that I wish to achieve. Now, if these two conditions are satisfied, then even if you apply the proportionality test, the answer will be that issuance of compulsory license will not result into expropriation. There's another important question that we need to discuss, and this is related to remuneration versus compensation. One question that can come to that can be raised here is that we are arguing issuance of compulsory licenses as expropriation, but whenever a compulsory license is issued, a remuneration is always paid to the patent holder. So the patent holder gets something in return. So if the patent holder is getting something in return, then why will the patent holder challenge this as a violation under the BIT? Now the answer to this question is, it can be looked at in two scenarios. Scenario one, which is highly unlikely but nevertheless a theoretical possibility, where the remuneration that is given to the patent holder is equivalent to the compensation requirement of the BIT. Now what is the compensation requirement of the BIT? If you look at the Indian model BIT, it provides that the compensation which is to be issued for expropriation, that's up there on the slide, shall amount to the genuine value of the investment expropriated immediately before the expropriation or before the impending expropriation became public knowledge, whichever is earlier, and shall include interest at a fair and equitable rate until the date of payment. So there are two criteria which have to be satisfied. The compensation should be equal to the genuine value of the investment which has been expropriated, and secondly, it shall include interest at a fair and equitable rate until the date of payment. Now, as you would appreciate, this obligation of compensation is far more onerous than the obligation of remunerating the patent holder. Especially if it will be a very useful exercise to compare the compensation provisions in the BIT with the adequate remuneration requirement given in the TRIPS agreement. Some scholars have argued that the adequate remuneration requirement given the TRIPS agreement says that the remuneration should only be adequate to cover the loss. It is not to cover the loss in terms of investment being totally expropriated. So theoretically, if this remuneration is equal to compensation, then obviously the patent holder has no reason to complain. So if that is the case, then the foreign investor will not challenge the compulsory license under the BIT, or even if the challenge is made, the challenge will not be successful, because then the host country can argue that I have fulfilled the conditions of the BIT, which is this issuance of CL is in public interest and full compensation has to be paid, has already been paid. However, this would also mean that India, if it makes this argument, will accept that it has expropriated foreign investment, which means that India will accept that by issuing a compulsory license, I have expropriated foreign investment. Now, it is highly unlikely that India or any host country for that matter will voluntarily accept that I have expropriated foreign investment. As you know, no state would voluntarily accept they have expropriated foreign investment, although we are a country which imposed retrospective taxation, so you never know. But because of the simple reason that if you voluntarily accept that I have expropriated foreign investment, that sends a very negative signal to foreign investor that damages your reputation, and all those things become very, very important. Scenario one is that let us assume that the host state, India or any state for that matter, gives a remuneration to the patent holder or directs the person to whom the compulsory license has been issued to give a remuneration to the patent holder, theoretically, which is equivalent to the compensation requirement in the BIT. This is highly unlikely, but theoretically let us assume that this is the case. Now, if this is the case, then the foreign investor will not challenge the issuance of compulsory license as a breach of the BIT. Or even if the foreign investor challenges it, that challenge will not be successful, because the tribunal will say that India has complied with the obligations in the BIT. The obligation is that if you expropriate, then it should be in public interest with full compensation. Now, this is a highly unlikely scenario, because if this were the case, then it would mean that India has to accept that it has expropriated foreign investment, which means that India will have to accept that issuance of compulsory license amounts to expropriation of foreign investment, which India would not like to do, or any country for that matter would not like to do. Then I come to the second scenario which you are referring to, which is that the adequate remuneration requirement under Article 31 of TRIPS does not mean that you have to compensate the foreign investor as if the investment has been expropriated. That requirement is less onerous in comparison to the compensation requirement of the BIT, which means that the remuneration that the patent holder will get will always be lesser than the compensation requirement of the BIT, which means that the foreign investor will therefore challenge that as a breach of the BIT and say that my investment has been expropriated. Now, if such a challenge is made, then yes, the Investment Treaty Arbitration Tribunal, whether we like it or not, will decide whether the compensation requirement of the BIT has been satisfied or not satisfied. If not satisfied, then what should be the compensation? In fact, then it will be the case of awarding damages, not just compensation, if it is established that issuance of CL is a violation of India's obligations under the BIT. So I am trying to present this scenario because this question was posed to me when I was working on this particular topic about 6 years back, that why should this be a problem for the foreign investor? Because whenever a CL is issued, the foreign investor will always be remunerated. This will still be a problem for the foreign investor because the remuneration that the foreign investor gets for issuance of compulsory license is far less than the compensation requirement of the BIT. So the foreign investor still has a genuine sort of a ground to complain for the issuance of compulsory license under the BIT. It depends on the language of the BIT. For example, in the India model BIT, if you read the compensation requirement, it is a little more than just compensation, because it says compensation shall amount to the genuine value of the investment expropriated, and it shall also include interest at a fair and equitable rate until the date of payment. Now, in certain BITs, you have the language of just compensation. That can come close to the adequate remuneration obligation under the TRIPS agreement. In some BITs, the obligation of compensation is far more onerous. So it will actually depend on the language of that particular BIT which is being interpreted. But I'm just taking this as an example to demonstrate that the compensation requirement is in the BIT is more onerous in comparison to the remuneration requirement for compulsory licenses. So the two questions that I posed: can issuance of CL be challenged as expropriation under the BIT? The first question, the answer is yes, especially in context of India, because all Indian BITs have a definition of investment which includes intellectual property rights. So it will not be a problem for the investor to overcome the jurisdictional hurdle. The second question of if such a challenge is made, then whether such a challenge will be successful. This is a question whose answer will depend on the arbitral discretion. As I have explained to you, that there are 3 tests which are available, and it will depend on which test that particular tribunal uses, because the text as of now is pretty vague. A better remedy to overcome this problem would be that in the text itself, some kind of immunity is created for issuance of compulsory licenses from being challenged as violation of BITs. This India has done. If India has about 70 odd bilateral investment treaties. India also has certain free trade agreements which have investment chapters. Now, if you go back and look at India's free trade agreements, or these are also known as comprehensive economic cooperation agreements with countries like Singapore, Korea, Japan, Malaysia, the investment chapter in these FTAs very clearly creates an exception or creates a safeguard or an immunity for issuance of compulsory license. It says that if a compulsory license is issued, such compulsory licenses cannot be challenged as expropriation under that particular investment chapter. So the text itself creates that kind of immunity or safeguard, which means that no foreign investor can ever challenge issuance of compulsory license. But since this does not exist in the 70 odd bilateral investment treaties, therefore investors can challenge it. And if India wants to create immunity or ensure that its CL does not get challenged, the investment treaty arbitration tribunal does not get to decide requirements such as compensation and things like that, then the only option available is to amend the text and to ensure that the text itself creates an exception on issuance of compulsory licenses. If there are any questions, I'll be happy to answer. Thank you.